I think we are going to share, we're going to roughly use the outline that I've prepared. Anthony's going to add a couple other subjects, and we're going to address each one of these bullets together. We each have separate comments. I will say that John Burge and Dennis, Jay Rempe, and the other speakers have eliminated a lot of the things. I don't want to repeat what they've talked about the North Pratt project and irrigation here in the valley and how it's unique, and we rely on full diversion maintenance to keep everything working. So I'm going to be able to we'll be able to go through these slides fairly rapidly. Is that correct, Anthony?
I think so. Can you hear me okay?
Yes. Could you hear me?
I can.
Where's the slide thing? Clicker. The first thing, Anthony, I'll start on this one if you don't mind. The first thing that is very timely today concerning the surface water rights here in the Panhandle is we have a lot of senior rights between 1880s and 1900. However, recently, Jim Ossie's here. He's partially in charge of doing water administration on the North Platte River. Our rights, our rights are still junior to a few in central Nebraska. Now, the case that I want to talk about is Carey versus Cochran. It's a 1940 case, but the Supreme Court there made a very strict interpretation of the prior doctrine. First in time, first in right. Professors Harmberger and Thorson addressed concerns and problems with that holding in their 1984 publication. But what happened there is the Supreme Court held that when the Department of Natural Resources, or its predecessor, administered the Platte River system for those the seniors west of Kearney, Nebraska, who needed 162 second feet to fill their allotments, that the state administered all the way up to the state line, over 200 miles away, the juniors, which included many districts out here. And the court said, it doesn't matter how much you have to turn off upstream to get those folks that are 162 because they're seniors. In fact, 700 second feet were turned off to get the downstream seniors their allotment. In addition, from the state line to that area in central Nebraska, it takes even sometimes more, about 10 days to even see any water that's shut off in the upper reaches to the middle reaches. Now, the other issue that was even mentioned in that case, at that time, and that's a long time ago when you think about it, 1940, I wasn't even alive, but the court noted there were 40,000 acre feet of groundwater development that was used that would influence river flows at that time. And that was in 1940. Today, and it's not just Dawson County, which was immediately upstream of the diversions, there are, I don't even want to estimate, but you all know what groundwater development's going on throughout the state since then. So, the point is that we don't think that's good law at all, because it doesn't even consider the damage you're doing to 5 times as much water as you're churning off in an arid area to the benefits that may be received for a small, lesser amount of diversion entitlement downstream. And again today, especially because a lot of these seniors in central Nebraska also have wells they can turn to. So a lot has changed since 1940. Lake McConaughey's operations, well development, and all sorts of efficiency improvements or degradations in the surface water systems. Anthony, do you have anything on that one?
No, I think you're right on point. Norman Dix, that's the Harnsberger book. Its main critique of Kerry v. Cochran was the refusal of the court to really take into account any level of sort of administrative deference that we might give the department in its oversight and management of the basin. And it took it took a very strict view. Part of it was associated with the nature of the review that the individuals were seeking. They sought a mandamus action, it's called, which is usually used to sort of force people to do purely ministerial sorts of activities, and the court went so far as to place it within that ministerial category. So it's a very difficult case, I think, for the department to live up to as it tries to manage, a very complex system, especially now. A lot of, like you said, a lot of things have changed since the 1940s. One of which is the scope of irrigated acres with groundwater wells throughout that basin. So it's kind of a continuing thorn in the side, I think, of folks who look at water management.
What I forgot to mention is Jim Osty, who's here from the department, has stated, has said that recently now, the department is administering some of the juniors, even some up north in the Panhandle, because of the water shortage in the Platte and demands from the Central Platte area, the few seniors that are down there. Let's see here. Okay, Dennis and John and others have covered the North Platte project thoroughly, so there's no sense talking about that. Whoops. Okay. And the project benefits. There's no question that it keys the whole system down here and benefits the entire state through the Platte drainage system. The other thing that all these benefits also include water quality. That fresh river water, relatively fresh river water, keeps our drinking water here in the valley within drinking water standards, and that's renewed every year. Anthony, just jump in if you want to say anything on any of these slides, please.
So just one thing on the significant project benefits, it is relevant to sort of an ongoing concern that folks like Central Public Power and Irrigation District have. Mike Klein used to say, I used to push Mike Klein on why he thought if Central were to pursue a Spear T type sort of piece of litigation against groundwater pumpers in any chunk of the basin, why he thought he would prevail under that reasonableness test that the court gave us in Spear T. And his point was always these project benefits. It's a relatively convincing case, and it's one thing I think that a lot of people in the water management world sort of keep in mind as they look at this. To the extent LB 962, the Groundwater Management Protection Act, doesn't get surface water interests to where they need to be, that Spear T fallback is always there, and this is the sort of thing that they would use to make that argument, as you well know.
Briefly, there's supplemental water supplies out here too, besides the North Platte project and the natural flow surface water irrigation districts. The Bureau, back in 1911, caused to be amended the so-called Warren Act to the Reclamation Act, which said that the North Platte project that Dennis talked about could sell excess water. Water that was in excess of project lands, which were project lands of about 224,000 acres. There was some litigation on that. I'm sorry, I'm talking in this thing. There was some litigation on that in 1989, actually. It wasn't decided until 99. And the federal court, in a reported decision there in the Goshen case, said that, in fact, the reclamation was violating the project district's contracts in allocating supplies in times of shortage between the districts and Warren. That had been done by a long practice over the years by the guy that was in charge of the Bureau in Wyoming at that time, called the Pete Anchor method. Well, the court ruled in favor of the project district, saying when there's short water, you get it first. to the detriment of the Warren contractors, the biggest one being Farmers and Garing and a few more. Now, as it turned out, people got tired of waiting for the judge to decide it, became nervous, and right before the decision was issued in 1999, entered into a new agreement, again, sharing the combined supply in times of shortage rather than completely cutting off Warren contractors. Then there's Glenville Water Service contracts. Bridgeport Mitchell Enterprise have them out here, totaling about 17,000 acre feet. Mitchell especially needs theirs almost every year. Bridgeport and Enterprise haven't used theirs as much. We'll talk about that later when it comes to water leasing for the program. Anything else, Anthony?
No, go ahead, Steve.
Now, this is surface water leasing and transfers at least are covered thoroughly in the statute. The thing I want to address briefly is the recently enacted or developed NRD and DNR acreage reserve program. It involves the Department of Natural Resources and four, I think it's South Platte, North Platte, Twin Platte, and Tri-Basin NRDs. And what this program generally does is it's designed to make more water available for juniors, and it provides a 30-year excuse for non-use by participating surface water users. It can be terminated by either party, and of course the carrot on the stick and the incentive for the appropriators is a lot of them, as you already heard, need money for infrastructure maintenance and significant repairs that none of these districts could afford on their own. My concerns are more cautions to the surface water appropriators about this. Now, surface water appropriators that I'm talking about are the irrigation districts and canal companies. They hold the water rights for their water users in a fiduciary capacity. The water rights attach to these individual lands, but neither the landowner nor the district or canal company can enter into a project like this without the consent of both. Ditch companies, districts, and companies basically get a basic diversion rate of 1 to 70. But because of the ditches out here and the sandy soil, and there are significant conveyance losses. They can divert 1 to 70 for every acre in their district, but there's no way they can deliver that much to everybody at once. So when a full capacity ditch is consistent with the original design of these ditches out here and essential to the operation of their delivery systems. And the carrying capacity function contemplates this, and I think it's inherent in a water right for irrigation because that's for the purpose of beneficial purposes, but also useful purposes. You couldn't get water to everybody unless ideally it would run at full capacity. Now, the potential reductions in diversions under this ARP program, I talked to Jesse Bradley, and it's still in the formative stage because under this program, DNR will be the one contracting with the appropriators instead of the NRDs. The NRDs may end up paying the appropriators for whatever compensation they're going to get, but DNR wants to make a standard lease for everybody. Of course, they would like as much water as possible, so initial proposals or the default position is that if you're going to put half your district into this program, and you've got the landowners go along with it, then half of your diversion right will be left in the river. Our position is, or the appropriator's position, for the most part. There are certain cases where that won't be a problem for a district or a canal company. But the North Platte NRD, in agreement with the department in previous years, has preferred to enter into leases, and appropriators found it much more palatable if all they left in the river at the diversion was the consumptive use. So the fellow that signed up his farm for 100 acres can't irrigate. And out of that total diversion, maybe half of it was consumptive use, or some figure like that. So it made sense to leave that in the river for stream augmentation or whatever purpose, and to allow the non-consumptive use to run through the system so that it worked efficiently for the other appropriators remaining the ditch company. The ditch company, the district, has a statutory and fiduciary obligation to get that water to their appropriators. So that's more of a caution to the appropriators before they sign up for this rather than anything else. So districts and companies have statutory duties that have to be protected. Additionally, because of the way it works out here, a lot of the surface water, natural flow people, their discharges go into other streams. One example is Enterprise dumps into Winter Creek, natural Winter Creek. And Winter Creek Canal Company below that takes the water out. So leaving all the water in the river will never benefit Winter Creek, who gets the return flows from Enterprise. That's only one of probably a half a dozen examples. We would like to see the program limited to consumptive use, and one more concern is we do not want to see this ARP be determined to be the exclusive tool that NRD can use for to augment river flows when it comes to surface water. As I said, the North Platte NRD in the past has entered into leases allowing the ditch company to divert the diversion less only the consumptive use. Sorry. Go ahead, Anthony. I took too long.
No, you're fine. In that idea of limiting this change to the consumptive use, it's replete in the statutes. And all of the statutes in, I think, 294, they deal with changes or what we call transfers under the statutes. They're all geared at looking at the consumptive use for precisely these reasons, the return flow concerns and the delivery to other people within the appropriations sort of service area. So.
Yeah, Anthony, I didn't make myself clear. I'm talking about a situation that is not a tube transfer. In other words, it's just reducing consumptive use of the North Platte NRD by leaving that in the river, not transferring it to any particular purpose.
Yeah, my point is just that if you were going to transfer it to somebody else, you'd have the consumptive use limit. So effectively what we're doing is basically transferring it to the river.
Right.
And so it should just be the consumptive use that's left.
Good. Okay, water leasing proposals to meet ESA demands. Dennis talked about it, or John, or both, Section 7 of the ESA, which was held as a big sword over the North Platte project before the Platte River program was agreed to by all parties. The Bureau's chief at that time said, look, they're going to go after the big targets first, and we could see the North Platte project just summarily losing 10 to 20% of its water supply. Of course, that was great incentive to reach an agreement with everybody, which Dennis, who's involved in it, can confirm has been going away quite nicely. Now, there's a couple things in the works, possibly. The North Platte project members are discussing a 16,000 acre storage space made available for the Platte River Recovery Program. Of course, that's going to involve the project districts, the Warrant contractors, the states of Wyoming and Nebraska, the program, and the Fish and Wildlife Service all have to agree. And I don't know where they are on that. I know there's a lot of interest, at least among the North Platte project and contractors. That would be a significant sum. Likewise, the Nebraska Glendo contractors, I can't speak for Central, they have a little different deal under Glendo than the districts out here. They just renewed their contracts for a 40-year term in 2009. It's for irrigation only. But the 1953 modification of the North Platte Decree allows that Glendo water to be used for fish and wildlife. So there's about 17,000 acre feet of storage space from our 3 Nebraska Glendo contractors that are in discussions with the program about leasing that. The biggest hurdle there is because of those contracts. If one doesn't need it, like Enterprise or Bridgeport in a particular year, which is quite often, the other one, Mitchell, can step in and take that water supply. So right now, Mitchell's not on board. I can understand their reasons why not. So we don't know if that'll go anywhere because, of course, the program wants a reliable water supply, which they're not going to get anyway from any storage deals, because we never have a guaranteed storage supply from any source. Anything on that, Anthony?
No.
Okay, I'm not going to talk about waters of the United States, all the law, and what is the waters of the United States. The purpose of the slides was a real general and probably not complete outline of what's gone on in the past, what's going on now. But my concern was, and I think Anthony can speak more about the law than I can, what's going to happen now, because President Biden directed all federal agencies to review all existing laws, rules, and regulations. And EPA and the Corps of Engineers announced their intent to include a rulemaking process that restores the protections in place prior to 2015 implementation and develop a new rule and durable definition. Well, without regard to politics, the rule, its implementation and interpretation and application has varied widely from the Obama administration. The Supreme Court threw its two bits in, and they could not agree exactly on a definition. The Trump administration and now the Biden administration. The concern is the uncertainty we have out here for farmers and ranchers. And the thing, the issues that come up out here, at least in my practice, have been the status of diversion, delivery, and drainage works, including temporary diversion dams, which are made of sand and wash out every year, in the eyes of the Corps of Engineers. Typically, we get complaints every year from landowners that some ditch companies put sand in the river and now he doesn't have water, etc. But those have so far been exempted from the 404 permit requirements. Stock ponds and crossings. Farmers and ranchers need those. They put a culvert in to pass the flow. Sometimes they raise the elevation of the culvert so it impounds some water. To get from one part of the ranch or farm to another and to water livestock. Now, I don't think we have time to go through the Kafkaesque experience I had with the Corps of Engineers many years ago in their interpretation. But the point is, we need to, and I'm sure like Farm Bureau and others are watching this very carefully, especially if this new, the Biden's administrative departments try to extend that rule to cover irrigation systems. Anthony, anything on that? I'm not even going to talk about the law because I'm afraid you'll upstage me.
Sure, I can chime in just a little bit. So, can people see me?
No.
No, it's just voice.
Fix that?
I don't know if you'd want to see me.
We're going to fix it.
So if people just keep in mind that first slide on waters of the United States, it has the general rule from the Clean Water Act, which is that thou shalt not discharge pollutants from a point source to navigable waters unless you have a permit. Right? At the end of the day, that's the general rule. And there's kind of three aspects to that are important. One is the source of pollutants. The second is the destination of those pollutants. And the third is the connection between the source and the destination of those pollutants. So those have been really the pinch points for some of the more difficult questions under the Clean Water Act. And those difficult questions they're pervasive. The first is, how far should the federal government's reach be? Right? Especially in a system that is supposed to involve states with a baseline of power. So the federalism aspect of the Clean Water Act really colors all of the conversations that occur with regard to the source and the destination and the connection of pollutants, because we're worried about a government that is reaching too far. The reason why that is so difficult in the Clean Water Act context is because of the goals of the Clean Water Act, which were to make all of the waters of the United States fishable, swimmable, suited for their intended purpose, and all of that by like 1985 or 1987, or whatever date that it was in the original act. And if you're concerned about water quality, you can't just focus on one particular body of water, because the impacts on that body of water's quality extend well beyond the edge or the bank or even the adjacent wetlands of that particular chunk of land, or that particular chunk of water. So the difficulty has always been in trying to figure out where exactly are we going to draw the lines under the Clean Water Act. And those lines have arisen in those three places. First with the source, second with the destination, which is the WOTUS question, and increasingly with this connection between the source and the destination. So for sources, the fights that we typically have over the sources that are regulated under the Clean Water Act are fights about what qualifies as a point source and what qualifies as a non-point source. That's been an ongoing point of sort of contention, and it exists a lot in agriculture, because we tend to think that agriculture involves a lot of non-point sources, right? But on closer examination, we do have plenty of point sources in agriculture. Manure spreaders, spray rigs, heavy equipment, deep chisels, all of those are within the definition of point source under the Clean Water Act. The real question becomes, when do those things, and they're all over the place, right? When do those things contribute waters to the United States in a way that brings them within the scope of the Clean Water Act, given the values of federalism and given the goals of the Clean Water Act that are in play? So we focused a lot on WOTUS, right? That's been the fight that we've been having for, when they told me how long I'd been teaching at the beginning of this thing, when Jesse mentioned I'd been here almost 20 years, good Lord, that's a long time. But ever since, one of the first things that happened when I started teaching was the Rapanos case. And that case was this fight about what is the scope of the Clean Water Act, the jurisdiction, the waters of the United States. So the fight about what waters are protected has been an ongoing struggle. And it varies from administration to administration, given their views on the appropriate scope of the federal government and the seriousness with which they take the Clean Water Act goals. And all of that's reasonable and understandable, and there's a lot of fights associated with that. But increasingly, in 2020, the U.S. Supreme Court decided a case called Maui County. The Maui County case was a case that involved injection wells on Maui that were injecting polluted effluent to subsurface structures. They were injection wells, right? And they were injecting that polluted water into groundwater, and then the pollutants were migrating with the groundwater to the coastal area, which is waters of the United States, quite clearly. So the question was whether or not those point source contributions of pollutants to the hydrologic system were regulable under the Clean Water Act, given their presence in waters of the United States. And the court concluded that they weren't, that the connection there was sufficient, that the connection there was the functional equivalent, in the language of the court, to somebody who was just dumping their pollutants into the waters of the United States. So what that case has given us is a 7-factor test to try to figure out when a release of pollutants from a point source and its ultimate destination in waters of the United States, when that connection is close enough. So that, I think, for the next 20 years, is probably going to be the fighting issue, which is under what circumstances does a release of pollutants on land that ultimately wind up in waters of the United States, under what circumstances is that direct enough to require the individual to have a permit? And that's a big question. And the Maui County case actually relied upon agricultural law cases in reaching its conclusion. The agricultural law cases that it relied on was a case called Care v. South v. Farms, which is a case out of the Second Circuit in I believe it was the 1990s, that found that runoff effluent from a CAFO land application area constituted a discharge of pollutants because the manure spreaders were point sources, maybe the swales that the pollutants were running through were point sources. In that case, it's been around for a long time, and I've argued about it for years and years now. But that case was the fundamental basis for the U.S. Supreme Court's opinion in Maui County, which opens the door to arguing about to what extent could agricultural applications of chemicals, herbicides, pesticides, nutrients, under what circumstances could those applications from point sources, from equipment, from sprayers, from dry rigs, under what circumstances could those be point source contributions of pollutants to waters of the United States? Just the involvement of rainfall doesn't seem to be enough. Just like the involvement of groundwater in Maui County wasn't enough to sever this causal connection between the release of the pollutants and their presence in the waters of the United States. So I think this is like one of the biggest issues facing the application and the development of the Clean Water Act going forward. And if the agency starts doing rulemaking on this, which it may, I haven't seen any proposals for it just yet, it's going to be another point at which we start fighting about the scope of the federal government, the scope of maybe waters of the United States. Those pinch points will still be in play. So those are some of the big issues I think that are facing us under the Clean Water Act, sort of beyond WOTUS. WOTUS we've sort of beat to death over the years. There's not much that can be said about it other than it's really hard to draw a line between where protection should begin and end. But once we get out of like the 404 context and we're not talking about wetlands, it's becoming increasingly difficult to figure out where exactly that line should be drawn. So that's kind of my take on where the Clean Water Act stands right now. We haven't answered any questions and we're asking a lot more. So
Thanks. Okay, yeah. Okay. 30 by 30. Anthony, I'm sure can have some comments too. I think we generally agree on it. It's a proposal by President Biden under the premise that nature is essential to the health, well-being, and prosperity of every community in America. I don't think anybody can argue with that. It was directing certain federal agencies to work with state, etc., other entities to address concerns with the disappearance of nature, climate change, and inequitable access to outdoors. Now, it's not a law, it is a proposal. It will generate a lot of studies again, of course. However, it is not per se a federal taking of ground or of land or water. One of the things that I was trying to figure out what issues I had, and Anthony pointed out that he and Dave Aiken are looking right now at what percent is already conserved. Is it 30% that's already under federal control? Is it 10%, or what percent is? So how far would this rule propose to go if it's ever enacted into any sort of a regulation? Don't know the answer, and maybe Anthony does. My concern was if, the sandhills in Nebraska are subprime real estate with respect to trying to get control of because of all the groundwater. And of course, I don't think, there are things such as conservation easements and other programs that don't necessarily require the transfer of title to the federal government. But if they own this property, what's going to be the consequences to the real estate valuation and tax consequences? As we all know, this state is way overboard on the burden that real estate has to pay for our economy, real estate taxes. So that could have some disastrous consequences. And then the other one is Federal Reserve water rights. Generally, when the federal government owns something, it carries with it the minimum quantity of water necessary to meet the primary purpose of the federal reservation. Well, most of the land out here, the primary purpose would, be
livestock, maybe some domestic, and possibly some irrigation. But having the federal government control lands raises those concerns. Whether they'll ever come to pass, I don't know, and whether this is just some more political fluff for us to consider, I don't know either, but we need to watch it and be concerned. Anthony, you probably have some comments.
Yeah, I mean, 30's main characteristic at this point is sort of the vacuum that it's created, right? And when the administration announced it, there were no details associated with it. When you leave that sort of a vacuum, of a space sort of in play, it allows all sorts of folks with all sorts of political agendas to chime in and villainize it and basically try to drum up, I think, political support using it. And I think that's probably the main characteristic of it at this point. I'm not tremendously worried about a big federal presence in agriculture for a couple of reasons. One is I've never seen across all of the Democratic and Republican administrations that we've had over the last 50 years, I've never seen a committed effort to somehow displacing agricultural production through federal intervention, other than maybe through temporary acreage reduction programs like CRP, CREP, and those sorts of things. So I think just like the basic political climate gives agriculture a lot of protection. The other thing that I think is interesting about it is, I mean, we see this idea of federal control over how agricultural lands are used. At the end of the day, the federal government already controls how agricultural lands are used. It offers crop insurance for only a certain set of activities. It provides financing for a part of, a broader way in which lands could be used. So the hostility to the federal government and its involvement in agriculture is at least inconsistent across those two arenas. I mean, we continue to want the federal government and government generally to fund efforts at like pollution abatement. That's one way of thinking about what conservation is on agricultural lands after all. We continue to want government to fund that sort of on a temporary basis, right? With things like EQIP and CRP and stuff like that. Sort of, we want the public to sort of rent their environmental benefits from us, but we seem very hostile to the idea of the government ever locking in its costs through some sort of a land purchase. So I think there's a lot of different perspectives one could take on this overall goal. But again, I'm not sure what the goal even is and how we're counting. Right? And Dave Aiken has made a lot of these points already, which is, what exactly are they counting? What qualifies as preservation and what doesn't qualify as preservation? And how much of it have we already done? Because I can see it being a situation where they've set a goal that they've sort of effectively already attained, so that then at the end of the day they can say, hey, look at this goal that we met. And it could be, there's a lot of things in between there, but there's really not much more that they need to do to be able to paint it as sort of a success story of conservation in order to, again, curry political favor. So I think there's a lot of different perspectives that are in 30 by 30, which is because of that gap, that vacuum, that space that the administration left when it announced it. I think that was, I don't know if it was intentional, but it seems to be sort of where we are.
Okay.
Are you guys putting me up on the stream my face?
Yeah.
Oh, good Lord. So, I wore a t-shirt because I've got my Lower Platte South NRD t-shirt on. And I think that's probably more beneficial to me in front of this audience than having a necktie on, but I don't know. I was hoping that maybe I wouldn't. I can't see any of you. I'm basically just talking to myself in the audience. I have no idea who's there. So take that into account with my comments. But.
Well, you've got some of your folks here from your NRD, and they all speak highly of you as well. I don't have much to say about the North Platte Decree unless you do, Anthony. I think Dennis has covered that really well. Just a basic apportionment in that case was 75% of the natural flow in the Guernsey to tri-state section was allotted to Nebraska, and 53 was amended to account for Glendale Reservoir, and the purpose of the Nebraska's allocation of 25,000 acre feet was included to be used for fish and wildlife. One more very important provision for irrigators out here: if there's space available, excesses in the system of up to 100,000 acre feet can be stored in Glendale and released for North Platte project natural flows. Anything on that, Anthony?
No, Steve. Good.
Okay. Okay.
Well, don't give them more in my face. It's fine.
Oh, yeah, sure. Okay, the last. One more slide. Well, there's only one more slide that I had, and that's on the Gary Fort Laramie tunnel collapse. That's been addressed as well, too. They've spent $10 million, Goshen and Gary Fort Laramie, and they're anticipating another 28 million. It's far from over. Those facilities, there's actually 3 tunnels. Number 2 collapsed, 1 and 3 aren't in the best shape, and the Bureau is requiring repair. Those tunnels were built by the Bureau and are still owned by the Bureau. They're reserved works. There are a lot of legal issues involved about who ultimately is responsible for costs, but due to the urgency considerations of getting water back into the systems, the legal issues have been set aside to try and get everything working. And it's working right now, but Tunnel 2, which is the one that collapsed, there's still discussions and arguments about what permanent repair scheme should be adopted. Tunnel 1, same thing. They're still discussing permanent repairs. They're all operational at this point. And Tunnel 3, which is solely in Nebraska, 1 and 2 are the responsibility of the cost is split between Goshen and Gary Fort Laramie. But Tunnel 3 in Nebraska will be solely Gary Fort Laramie. They're all working, but are in need of substantial renovation repair. And frankly, a lot of it is due to failure to construct it according to the Bureau's own specs. Well, it wasn't the Bureau then, whatever it was, back 100 years ago when it was built. But regardless, right now we're trying to get water into the system and get them fixed for good. I think they'd be encouraged about what Congressman Bacon had to say about the FEMA funds, and that's the big issue right now, is where we're going to get the money to fix all this. That's all I have. That's all I have.
So we have a few minutes left, don't we, Steve?
Excuse me?
Do we have a few minutes left?
Well, this is what Representative or Congressman Bacon just got addressing, that there could be FEMA funds available, so I hope he's right. They're searching every source they can think of at this point.
So, yeah, we do have about 10 minutes for questions for Anthony or Steve.
Hi, Anthony. Thank you. I have a quick question regarding WOTUS, and now that we have the Maui County ruling, and the new administration is looking at reviewing the WOTUS rule. Is there any discussion or talk about the ag exemptions under Section 4F going by the wayside because of that Supreme Court ruling, and something coming up again like the Des Moines waterworks case against the upstream districts.
Sure. So it was kind of cutting in and out on you.
Sure, I can repeat the question if it would help.
Yeah, so the question was about the scope of the 404F exemptions and the extent to which, an administration could kind of change those or somehow.
With the Maui County case ruling. Go ahead, sorry.
I think we were talking over each other there, but Maui County's impact on those and that sort of thing. So so the 404F exemptions are exemptions from the permit requirement for dredge and fill permits under 404 of the Clean Water Act, right? So normal farming practices, for example, are exempted from a 404 permit. That doesn't necessarily mean that normal farming practices couldn't contribute pollutants to waters in the United States in ways that trigger an obligation to get the 402 permit, right? And so that's actually one of the issues that sort of the scope of 404F is, it really only goes so far. It only goes so far as to provide exemptions for normal farming activities when they would otherwise violate Section 404 of the Act, not Section 402. So that's one of the issues. But there is an exemption in effect for agricultural activities to some extent within 402. And it comes in through the agricultural stormwater discharge exemption. Now, there hasn't been a lot of attention to the agricultural stormwater exemption, but when I look at the statute and its history and the way in which it was sort of created, was that the agricultural stormwater exemption was adopted at the same time as when we were expanding the Clean Water Act to cover stormwater discharges from municipalities. And you think of those, like we've got a big stormwater system here in Lincoln, it has to have a Clean Water Act permit. And what that means is, effectively, we have to implement best management practices in the area that's being drained in order to better the effluent quality of the water that we're discharging through our stormwater system. Now, that would have been a difficult thing for agriculture to do. And so the exemption was geared at shielding the agricultural stormwater dischargers, that is, the drainage works, the drainage canals, those sorts of like financing quasi-governmental structures that we have out there. The idea was to exempt them from any permitting requirements that they would experience, because that would be a heavy lift for agriculture. It doesn't, however, necessarily mean that you couldn't discharge pollutants in ways that flow through an agricultural stormwater conveyance that is otherwise shielded. And that's consistent with Maui County, which basically said the existence of groundwater in this causal chain doesn't cut it off. Right? It doesn't cut off the prospect of permitting. So I think it's a pretty open question as to what extent some agricultural applications of, for example, manure or fertilizers or whatever, particularly close to rivers and streams or maybe wetlands that are within the scope of the Clean Water Act, to what extent those could trigger some Clean Water Act obligations, specifically a 402 permit of some sort. Now, we can write 402 permits on a regional, an industry-wide, or a general basis and try to do it that way. But I think those are the big issues facing the Clean Water Act is, okay, now what does the stormwater exemption mean exactly? And what is this connection between the two? And when we've been faced with uncertainty in the past, what we've tried to do, what we've done first is litigate, right? And so we've got some of that. And then there's been some efforts at rulemaking. And so I think maybe we'll see an effort at rulemaking on that. And then that'll be an opportunity to comment and to talk about the different ways in which this is just going too far. It's not really a problem. It's a solution in need of a problem. All of those kinds of debates. I don't know if you guys can still hear me, but I did want to apologize for not getting out to Scottsbluff. I had planned to, and then the schedule just fell apart. The kids had to go back to school, and getting the lump school up and running here in the beginning of some increased COVID activity is being, it's it's interesting these days. So I apologize. I'll get out there soon, I hope.
We have time for one quick question, if anybody's got one. Are we getting ready for lunch? Okay, well, let's give a round of applause to our speakers.